So, William, can you tell me some more about proving causation in tort and contract by reference to the hypothetical conduct of the defendant? Is this just about what the defendant would have done if they'd not been negligent?
Yes and no. I think it's about two alternative ways in which a claimant may prove their case on causation. Suppose they've already proved that the defendant acted negligently. The next question, of course, is whether that negligence caused any loss. It turns out from a case called Hertenstein that a claimant might do this in one of two ways. The first way would be by showing that if the proven negligence had not occurred, then any non-negligent defendant would have acted in a way that would have stopped loss occurring to the claimant. But even if that fails for the claimant might try or may try a second approach by showing that even though the first one doesn't work, nevertheless, had there been no negligence, then this particular defendant, a particular person in question, would have acted in a way that would have avoided loss to the claimant, even though a non-negligent defendant might have acted differently and in a way that did not avoid loss.
That's a bit abstract. Can you give an example of how that might work in practice?
Well, yes, the facts of the Hertenstein case, the decision of Mr. Justice Leggett, it show how this works. It's an unreported case, so you have to dig about a bit to get into the facts, but I think it's certainly worth it. Mr. Hertenstein was in the happy position of being able to and wanting to buy a yacht, and he engaged solicitors who are well known for maritime law, Hill Dickinson, very well known, to act for him. Now, the seller of the yacht was a shell company with no assets, so obviously a risk that if something went wrong, it wouldn't be worth suing it. And Mr. Lawson of Hill Dickinson negligently advised Mr. Hertenstein that he'd obtained a personal guarantee from a Mr. Candy, who owned the seller company, so de facto was the owner, and indeed that the guarantee covered the condition of the yacht. Mr. Hertenstein bought the yacht, and I think you can probably see where this is going next in the story. Within a few hours, the engines of the yacht failed, whilst I'm not very good at sailing, having passed RYA level 2, I understand that if you have a yacht, unless you're mad keen on sail, you really do want to have some engines. So Mr. Hertenstein wanted to call on this guarantee, and he discovered that the guarantee from Mr. Candy didn't actually cover the condition of the yacht, or indeed the condition of the engines, contrary to what Mr. Lawson had told him. He was somewhat disgruntled, I think, and he sued Hill Dickinson, who had been negligent on the judge's findings, and the question of causation arose. Now, the normal approach, as I was saying before here, would be for the claimant to say, as they did say, that in these circumstances, the solicitor should have acted non-negligently, and that if the solicitor had acted non-negligently, the claimant's loss would not have occurred. Mr. Hertenstein did allege that, and he said that if Mr. Lawson had behaved non-negligently, he would have asked Mr. Candy for a guarantee covering the condition of the yacht, and that if that had been done, Mr. Hertenstein's loss would have been avoided. But the judge rejected that argument. He held that Mr. Lawson could, without negligence, have decided not to request a guarantee from Mr. Candy, which covered the condition of the yacht. So you might think that would be doom and disaster for the claimant's case on causation. It wasn't. The judge went on to hold that that finding wasn't fatal to Mr. Hertenstein, and that's because the judge also found that if Mr. Lawson had not been negligent, Mr. Lawson, would have realized that he hadn't asked for Mr. Candy for a guarantee which covered the condition of the yacht, and Mr. Lawson, would then have sought such a guarantee from Mr. Candy, even though if he hadn't done that, he wouldn't have been negligent at this stage, the reasoning. And so Mr. Hertenstein was entitled to be put in the position he would have been in if Mr. Lawson had sought that guarantee from Mr. Candy, which would have been that Mr. Hertenstein didn't suffer any loss.
So that's an example then of the second way of proving the loss, which you mentioned.
It's the second way, exactly. It's an approach, I think, derived from clinical negligence cases, and anyone running this argument might be well advised to look at those cases. And so it does give claimants a second string to their bow, though it may be quite rare to find facts, I think, that actually come within that second way of putting it.
Mm.